Gentlemen of the jury, at the beginning, I want to thank you for your patience during this long trial in which you have listened to the evidence and borne with the court and counsel. During the course of the trial, there have been various motions made by the attorneys and various objections made to the introduction of evidence. My rulings on those motions and those objections were on matters of law with which you have no concern. So you will pay no attention to my rulings in your deliberations. You are concerned solely with the facts of the case and not with the law, except as I give you the law in my charge. In summing up to you, the counsel on each side have made statements of fact or told you what their inferences from the facts were, and I, in my charge, will refer to the facts. You are not bound by any statement of fact made by either counsel or myself. Your own recollection of the evidence, as you heard it on the stand here, is to govern you in your deliberations. You are at liberty to disregard the entire testimony of any witness that you think deliberately testified falsely to any material fact. Your verdict must be not founded on sympathy for either side or prejudice against either side. Your verdict must be on the evidence and on the evidence alone, irrespective of any personal feeling that you might have toward one or the other of the parties or against one or the other of the parties. You are to scan more closely the testimony of an interested witness than you would that of a disinterested witness. In a case like this, an action claiming damages for alleged negligence, the burden of proof is on the plaintiff. He is the one who comes into court and asks you to take the money from the pocketbook of the defendant and give it to him because of some alleged negligent act, and the plaintiff has the burden of proof on two propositions. He must prove to you, gentlemen, first, to your satisfaction, that the negligence of the defendant was the sole cause of the accident, and he must prove to your satisfaction, secondly, that he was guilty of no contributory negligence. In other words, he must prove to you that he did nothing which in any way brought about the accident. The burden of proof on those two propositions is upon the plaintiff. He must prove that two propositions to you by what we call the preponderance of evidence. The preponderance of evidence means that the testimony of the plaintiff must outweigh the testimony of the defendant. This does not mean necessarily that the plaintiff must call the greater number of witnesses. It refers to the quality of the evidence rather than to the quantity of the evidence. If the evidence offered by the plaintiff carries to you greater conviction of truth than the evidence presented by the defendants, the requirement of preponderance of evidence is satisfied. If, on the other hand, the testimony is evenly balanced, then the plaintiff has not sustained the burden of proof, and your verdict will be for the defendant. In deciding this case and in determining those two questions as to the alleged negligence of the defendant and as to whether the plaintiff was guilty or not of contributory negligence, you are to be guided by the legal definition of negligence, and that is this: negligence is the failure to exercise that degree of care which a reasonably prudent man would exercise under the same or similar circumstances. That is your legal definition of negligence to judge the conduct of each of the parties to this action. In this action, the plaintiff claims that on the morning of the accident, he read an advertisement for linotype operators of some firm in the building in question and proceeded to that building to look for the job. That he went hurriedly through the door, noticed there was a printing firm on the 5th floor, and proceeded to that elevator on the 5th floor through in order to catch the elevator, that he then went along with other passengers, that the elevator stopped at the 5th floor to let out another passenger. He has testified that it was dark, that he could see his hand 2 or 3 feet before him. His claim is that that open door was in some way opened after it was shut by the operator, which he says was due to the negligence of either the defendant's operator, who was the agent of the defendant, or some defect in the machinery or devices by which that door was controlled, for which the defendant is answerable in this action. The plaintiff claims he is free from contributory negligence because he had left the elevator safely and he had a right, when he came back, to assume that it would be in a safe condition and that the door would be closed. That is,
That's good.